Hello guys, welcome to the Century Law Firm official YouTube channel. Myself Yuvraj Anand. Today I will try to explain the topic known as arbitration and judicial intervention in arbitration proceedings. First of all, let's try to understand what is arbitration. Arbitration is one of the methods in ADR. What is ADR? ADR is also known as alternative dispute resolution. In arbitration, two conflicting parties appoint a neutral third person to settle their dispute. That person reviews their arguments and evidence and issues a decision which is known as arbitral award. This is the basic explanation of arbitration. Let's try to discuss what are the benefits of arbitration and why it is preferred over litigation in commercial disputes. The first benefit would be that the arbitral award is enforceable. Enforceable का मतलब है कि जो arbitral award होता है ना, वो डिक्री की तरह ट्रीट किया जाता है और वो आप कोर्ट अप्रोच कर सकते हो और एग्जीक्यूट करा जा सकते हो. द सेकेंड पॉइंट वुड बी द आर्बिट्रेशन इज फाइनल. फाइनल का मतलब है कि आप चैलेंज नहीं कर सकते हो आर्बिट्रल अवार्ड को. चैलेंज इन द सेंस आप हाई कोर्ट नहीं जा सकते, सुप्रीम कोर्ट नहीं जा सकते उनको चैलेंज करने के लिए, जो आप ऑर्डिनरली लिटिगेशन में ये प्रोसेस फॉलो होता है. द थर्ड पॉइंट वुड बी द आर्बिट्रेशन इज एन प्राइवेट प्रोसीडिंग्स. इफ आई हैड टू एक्सप्लेन, द कोर्ट जो है वो ओपन स्फीयर में कंडक्ट करता है. उसके डिसीजंस या फिर उसके प्रोसीडिंग्स पब्लिक के लिए ओपन होते हैं. बट आर्बिट्रेशन में एक आर्बिट्रेटर और सिर्फ टू कन्फ्लिक्टिंग पार्टीज ही प्रेजेंट होती है क्लोज्ड एटमोस्फियर में और उनके डिस्प्यूट सेटल होता है. The next point would be that their relations are maintained. In litigation, जो majorly the family relations or the good relations that are needed or that are established over years by companies or parties are destroyed. But arbitration ensures that they are maintained. The fifth and final point would be the timely execution and disposal of the suit. Arbitration के जो मैटर्स होते हैं अधिकतर कुछ हफ्तों या कुछ महीनों which is probably less than a year में सेटल हो जाते हैं. लिटिगेशन में कुछ सालों, 5 सालों, 10 सालों तक भी खिंच जाते हैं मैटर्स और वो सेटल नहीं होते और कुछ फायदा नहीं होता. Arbitration in India is governed by Arbitration and Conciliation Act 1996, which was implemented to abide by UN Citral Model Law on International Commercial Arbitration. Both Article 5 and Section 5 of Arbitration and Conciliation Act 1996, which is Domestic Indian Statute, and International Commercial Arbitration of UN, shares same content. Let me go over Section 5 of that act. Notwithstanding anything contained in any other law for time being in force, in matters governed by this part, no judicial authority shall intervene except where so provided in this part. Let's break down this section number 5 of our act. Notwithstanding anything contained in any other law for time being in force. अगर हम इसको देखेंगे ना, इसका मतलब ये है आर्बिट्रेशन एंड कंसिलिएशन एक्ट है ना, वो बाकी सारे जो भी लॉज है जो भी आर्बिट्रेशन को गवर्न करते थे इससे पहले, वो उन सब से सुपीरियर है और जो इसमें लिखा गया है वही फॉलो किया जाएगा. बाकी जो एक्ट्स है या फिर जो रूल्स है वो ओवरराइड नहीं करेंगे, ये ओवरराइड करेगा. आगे बढ़ते हैं. इन मैटर्स गवर्न्ड बाय दिस पार्ट नो जुडिशियल अथॉरिटी शैल इंटरवीन. जो इन मैटर्स गवर्न्ड बाय दिस पार्ट, इसका मतलब जो भी मैटर्स है जो आर्बिट्रेशन एंड कंसिलिएशन एक्ट गवर्न करता है, जिसमें जुडिशियल अथॉरिटी इंटरवीन नहीं करेगी, मतलब दखल अंदाजी नहीं करेगी, एक्सेप्ट वेयर सो प्रोवाइडेड इन दिस पार्ट. वो दखल अंदाजी वहीं कर सकती है जहां पे स्पेसिफिकली उनको पावर दे रखी हो करने के लिए. अब मैं आपको बताना चाहूंगा व्हाट इज जुडिशियल अथॉरिटी. The judicial authority is not limited to courts only. It extends to court, tribunal, consumer dispute resolution forums and many other things. Let's go over the few grounds that are used by court to set aside an arbitral award. Section 34 of Arbitration and Conciliation Act sets those few grounds. Let's go over them. Invalidity of the arbitration agreement or void arbitration agreement, the incapacity of the parties, improper notices given to parties, the tribunal not being composed with the consent or in accordance with the parties, and many others. Let's go over section 34, section 2, clause B. The award being issued or the matter in hand is incapable of being settled by arbitration. The fifth, the award that is issued by a court is against public policy. Earlier, before the 2015 amendment, the specific provision that an award is against public policy was misused and particularly used to challenge the validity of arbitral awards. However, after 2015, the arbitral award or the grounds on public policy were exhaustively defined by an court. Let's go over those three grounds. First would be that an award that is obtained by fraud or coercion. The second ground would be an award that is against the fundamental policy of India. And third ground would be an award that is against the principles of morality and justice. क्या इसका मतलब ये है जुडिशरी आर्बिट्रेशन में बिल्कुल इंटरवीन नहीं कर सकती? ऐसा बिल्कुल नहीं है. उनका जो रोल है वो सपोर्ट और एडमिनिस्ट्रेटिव का है. वो चार सिचुएशन है जहाँ पे वो इंटरवीन करते हैं. चलिए उनके ऊपर डिस्कस करते हैं उनको. पॉइंट नंबर 1, बिफोर आर्बिट्रल प्रोसीडिंग्स. द सेक्शन 8 ऑफ द आर्बिट्रेशन कंसिलिएशन एक्ट गवर्न्स the referral to arbitration. If judiciary finds between the party there was a prior arbitral agreement, it shall necessarily refer the parties to arbitration even if it had the proper jurisdiction to entertain the suit ordinarily. Section number 9, which governs during the arbitral proceedings. The judiciary has administrative work of interim functions. Interim function is temporary and injunctive in nature. They ensure balance of convenience and reduces irreparable harm after the arbitral proceedings. Section 34 and Section 36 of Arbitration and Conciliation Act governs after intervention of judiciary after arbitration award has been passed. Section 34 sets the only few grounds by which the arbitral award can be set aside by the judiciary, and section 36 mentions how an arbitral award can be enforced by a judiciary body. The fourth and final intervention would be the appeal orders, and appeal orders is governed by section 37, and they are of two types: appeal from court and appeal from tribunals. Let's go over an example of section 8 in which court refers a dispute to arbitration. Specifically in the case Mountain Corporation Limited versus Pink City Midway Petroleum. In this case, the Supreme Court had recognized when there exists an arbitration agreement in the contract deed or memorandum of understanding between the conflicting party, it shall necessarily refer the suit to arbitration, even if it had the authority to entertain the suit ordinarily. Let's go over an example of section number 9 of Arbitration Act in which interim relief is governed. Interim relief exists to protect the right and interest of the party while the suit is ongoing, so that then when an award is passed by an arbitrator, it does not become frustrated. It uses the principle of the balance of convenience and prevention of irreparable harm. Let's go over one case law. MS Sundaram Finance Limited versus MS NEPC India Limited. In this, the Supreme Court had clearly emphasized that section number 9 exists so that a suit proceeding remains smooth and are not hindered by the limitation of harm. It is not an ground which should be exercised by a party to hinder the proceedings of the arbitration unnecessarily. when a time limit to challenge an arbitral award under section 34 is passed, or when a challenge is set aside by a court, the arbitral award becomes final and it becomes enforceable according to the section 36 of Arbitration and Conciliation Act. Ordinarily, after 3 months, when an arbitral award is passed and no action is taken for being challenging it or setting it aside, an award automatically becomes enforceable and is treated as a civil decree passed by a सिविल कोर्ट। अब जुडिशरी का फाइनल इंटरवेंशन समझते हैं आर्बिट्रेशन में। अब वो जो है अपीलेबल ऑर्डर्स में होगा। अपीलेबल ऑर्डर्स जो है सेक्शन 37 ऑफ आर्बिट्रेशन एक्ट में गवर्न होते हैं एंड दीज वुड बी एन रिफ्यूजल टू रेफर एंड पार्टी टू आर्बिट्रेशन अंडर सेक्शन 8। द सेकेंड वुड बी refusal or granting interim measures under Arbitration and Conciliation Act, or under section 34 refusal to set aside or granting an arbitral award. These are the few grounds which are appealable in civil court. And finally, to sum up all my arguments in layman terms, मैं ये कहना चाहूँगा कि जो arbitration जो है overall काफ़ी एक efficient और एक अच्छा मैकेनिज्म है कमर्शियल डिस्प्यूट्स के लिए, क्योंकि उसमें समय भी कम लगता है और वो प्राइवेट मैटर भी होता है और वो सालों तक खिंचता भी नहीं है। और जो जुडिशरी की इंटरवेंशन होती है उसमें बहुत लिमिटेड होती है, उसमें बस जुडिशरी एक सपोर्ट में और एक एडमिनिस्ट्रेटिव रोल में काम करता है। तो आर्बिट्रेटर की इंपॉर्टेंस इंडिया में बहुत ज़्यादा है और आने वाले सालों में वो और बढ़ेगी। थैंक यू।